Namaskar and a very good evening to all. I, on behalf of Adhivakta Parishad, Himachal Pradesh, welcome you all to this fifth lecture of Dr. B.R. Ambedkar series. And thank you all for joining us. I am Advocate Vivek Sharma and is joined today by Advocate Kavar Ajay Singh Ji, practicing advocate at District and Sessions Courts, Dharamshala, and the President of Adhivakta Parishad, Dharamshala Unit. And to speak on today's topic, we have our guest speaker, Shri B.S. Soni ji, retired district and session judge, and now practicing advocate of our own High Court. Today, he is with us to deliver his lecture on today's topic, that is reverse burden in NDPS Act and special rules of evidence. The recorded version of today's lecture will also be available to you on our YouTube channel of Adhivakta Parishad Himachal Pradesh. So kindly do like and subscribe our YouTube channel. You can also join us through Facebook and Twitter. Please keep on commenting on today's topic in the comment section, as we'll have a separate time slot for the question and answer round after the lecture. I, on behalf of Adhivakta Parishad Himachal Pradesh, welcome our today's distinguished keynote speaker, Shri B.L. Soni ji, retired district and session judge, respected Zonal Secretary of Adhivakta Parishad, Shri Padam Kant Dwivedi ji, State President of Adhivakta Parishad, Shri Ravindra Prakash Verma ji, State Working President, Shri Avinash Sharma ji, State General Secretary, Amit Singh Chandel ji, our National Executive Member and Additional Solicitor General of India, HP High Court, Shri Rajesh Sharma ji, other distinguished participants and respected members of Adhivakta Parishad. To this fifth lecture of B.R. Ambedkar series being organized by Adhivakta Parishad, Himachal Pradesh. Though our keynote speaker needs no introduction as he is known to most of us, but before starting today's lecture, it is my duty to give a brief description of our keynote and introduce him to those who are not familiar with him. Shri B.L. Soni ji was born on 26th January 1953 at Sundarnagar, District Mandi. He graduated from HP University Shimla and obtained bachelor's degree in law in year 1982 and postgraduate diploma in personal management and labor welfare in 1983 from Himachal Pradesh University. He joined HP Judicial Services on 1st February 1984 and served as subordinate judge at Mandi, Dharamshala, Kangra, Rampur Bushehr, Amb, Sarkaghat, Mirpur, Thiog, Behra, Paonta Sahib. He served as a senior sub-judge cum chief judicial magistrate, Lahore and Spiti at Kullu and Kullu. Joined as presiding officer, Fast Track Court, Dharamshala, Shimla, Solan. He also served as a joint director, HP State Judicial Academy, Shimla. He was appointed as a member of Higher Judicial Services and joined as additional district and session judge to Dharamshala on 28th December 2008 and as a additional district and session judge 1 Kangra at Dharamshala with effect from 18 June 2009. He assumed the charge of district and session judge cum special judge forest with effect from 15th May 2010 till his retirement on 31st January 2013. Presently, he is practicing advocate in the Honorable High Court of Himachal Pradesh at Shimla, and he has been kind enough to spare his valuable time at such a short notice and has consented to be our keynote speaker on today's topic. notwithstanding between you and the key speaker for today, I'll request our keynote speaker to deliver today's lecture. Over to you, sir.
Well, good evening to all. Whatever is said may be true, must not be true. The lecture for which we will deliberate today relates to criminal jurisprudence, especially the Narcotic Drugs and Psychotropic Substances Act. All are well aware that in criminal jurisprudence, the fundamental principle is accused is presumed to be innocent unless proved to be guilty. And along with it, another principle is that prosecution must prove its case beyond reasonable doubt. These are two fundamental principles of criminal jurisprudence. And if we go through the history, a light reverse burden provision is also existing in the Indian Evidence Act. The section 106 speaks of it. Whenever the facts are in the personal knowledge of the accused, it is the obligation on the accused to explain the circumstances. But the parliament thought it better to enlarge its scope, and that's why we see now reverse burden provision in the NDPS.
I think there is some network problem. We'll get back to you.
In section 35 and 54 of the NDPS Act. It is a very harsh provision. But how it is operated, we will discuss it. The challenge was laid to the constitutional validity of these provisions before the Honorable Supreme Court of India in a celebrated case, Noor Agha versus State of Punjab. And the Honorable Supreme Court considered various provisions of the various countries, including res ipsa loquitur. And keeping in view the ill effects of the drugs and psychotropic substances, they came to the conclusion that a balance has to be struck between the personal liberty of an individual and the larger protection to the society. They considered Article 21 of the Constitution of India as well and came to the conclusion that these provisions are constitutionally valid. And now, having so said, the Supreme Court also examined when, where, how the reverse burden would operate. If you go through the plain reading of section 35 of the NDPS Act, it says In any prosecution for an offense under this Act, which requires a culpable mental state of the accused, the court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. Explanation. In this section, culpable mental state includes intention, motive, knowledge of a fact, and belief in or reason to believe a fact. Subsection 2. For the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. Now, does it mean as soon as prosecution is late, such a presumption is available, or the foundation facts have to be first proved? Now, the connecting provision is section 54. Now, it also speaks of presumption. Presumption from possession of illicit articles. In trials under this Act, it is presumed, unless and until contrary is proved, that the accused has committed an offense under this Act in respect of A. Any narcotic drug or psychotropic substance or controlled substance. B. Any opium, poppy, cannabis plant or coca plant growing on any land which he has cultivated. C. Any apparatus specially designed or any group of utensils specially adopted for the manufacture of any narcotic drug or psychotropic substance or controlled substance. Or D. Any materials which have undergone any process towards the manufacture of a narcotic drug or psychotropic substance or controlled substance, or any residue left of the materials from which any narcotic drug or psychotropic substance or controlled substance has been manufactured. Now, by going through these provisions, presumption is required to be raised by the court, and presumption is one of mental state and illicit possession. Section 35 speaks of launching of prosecution, and section 54 speaks of trial. This riddle was solved by the Honorable Supreme Court in and it was clear.
I think there is again some network issue with our keynote speaker.
It was cleared by the Honorable Supreme Court that this presumption is not available as soon as FIR is lost or investigation is completed. This presumption would arise only when found beyond reasonable doubt. Only then this presumption could be availed of by the court. This position was time and again clarified and reiterated by the Honorable Supreme Court. And there are two cases, Gorakhnath AIR 2018-704. Clearly, the NDPS Act provides for a reverse burden of proof upon the accused, contrary in the normal of criminal jurisprudence. for presumption of innocence unless proved guilty. This shall not dispense with the requirement of the prosecution to having first established a prima facie case. Only thereafter the burden will shift to the accused. The mere registration of a case under the Act will not ipso facto shift the burden on to the accused from the very inception. Compliance with statutory requirements and procedures shall have to be strict and scrutiny stringent. If there is any iota of doubt, the benefit shall have to. Now, again in 2018, the Supreme Court reiterated it. AIR 2018 Supreme Court 3853. It is a three-judge judgment. It also said, unlike the general principle of criminal defense, the accused is presumed innocent unless proved guilty, the NDPS Act carries a reverse burden of proof under Section 35 and 54, but that cannot be understood to mean that the moment an allegation is made and the FIR recites compliance with statutory procedures leading to recovery, the burden of proof from the very inception of the prosecution shifts to the accused without the prosecution having to establish anything more. The presumption is rebuttable. Section 35(2) provides that a fact can be said to have been proved if it is established beyond reasonable doubt and not on preponderance of probability. The stringent provisions of the Act, such as Section 37, the minimum sentence of 10 years, absence of any provision for remission, do not dispense with the requirement of the prosecution to establish a prima facie case beyond reasonable doubt after investigation, only after which the burden of proof shall shift to the accused. The case of the prosecution cannot be allowed to rest on a preponderance of probabilities. Now, what is going on? As soon as FIR is lost, immediately a presumption is raised in both the sections, Section 35 as well as Section 54. The only excuse is that these presumptions will continue till these are dispelled at the trial. This is not the mandate of law. What is the mandate of law? That reverse burden would only be available to the court after the foundation facts have been proved at the trial, that too beyond reasonable doubt. And there is a direction, and the celebrated case is Mandpi Cooperative Bank Limited versus Nimesh B. Thakur, 2010, Volume 3, Supreme Court Cases 83. What it says? It says, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. There is no discretion. Simple reading of the provisions, it is not sufficient to raise the presumption at the initial stage. We are governed by rule of law, and both these provisions have been explained, interpreted by the Honorable Supreme Court, and that is the law as declared by the Supreme Court under Article 141 of the Constitution of India. There is no option. This is a reverse burden, and it can only be charged by, if raised, by preponderance of probability, which concession is only available to the accused. And how, when, in what manner it is to be discharged, it is a matter to be decided by the party. There is another aspect that if the evidence is collected in violation of the mandatory provision of law, that evidence cannot be taken as valid evidence and cannot be utilized at the trial. The mandatory provisions are procedures prescribed under the statute itself, and those provisions are mandatory in nature. Any violation of it renders the evidence inadmissible. There are the popularly and generally applied provisions, Section 42 and Section 50. 42 is in two parts. If the information as to the contraband material being possessed is available to the police officer, then it requires to be reduced into writing and a copy sent to the superior officer. Secondly, if on the spot, prior to the conduct of the search and seizure, the officer entertains that the accused has in his possession the contraband material, then he has to record the reasons of his belief and send a copy thereof to the higher officer. This provision was also subject matter of debate, dispute, and the one view was that substantial compliance would be sufficient. It held the field for 2-3 years. Now, finally, in Karnail Singh case, the Supreme Court said it that if the police officer happens to be on patrol or outside his police station and there is urgency, there is possibility of the evidence being removed or obliterated or destroyed, then the Supreme Court said it that the detection, seizure can take place and the information can be sent, reduced into writing after search and seizure. Another situation is that the information is available and there is a time. Then the normal procedure has to be followed. Information has to be reduced into writing, copy thereof sent to the superior officer, and thereafter the search and seizure has to take place. there is a leverage now granted, but within a reasonable time, information has to be sent, reduced into writing, sent to the superior officer, and that provision is still mandatory. The normal rule of evidence do not apply in the matter of NDPS. Normal rule of evidence is that evidence, even if collected illegally, that can be accepted by the court. The court is not concerned how the evidence was collected, obtained. Court was concerned that evidence is there. If it is good and valid, finding can be recorded. This is not so in the case of NDPS Act cases. The Supreme Court has considered this aspect in Baldev Singh case, and Constitutional Bench came to the conclusion that the evidence on which prosecution has to rely must be in tune with the special statute. If evidence is collected in violation of the statutory provision, it will hit Article 21 of the Constitution of India. There is a celebrated case, AIR 99 Supreme Court 3672, perhaps. That evidence collected in violation of procedure contained in section 42 and 50 renders the evidence inadmissible at the trial, and it cannot be utilized by the court. Why it is so? The provisions are very stringent. Punishment is also stringent. The reverse burden is there. There is a watertight compartment for the accused. His liberty cannot be curtailed by applying general law, and that's why special procedure has been prescribed. It is also a settled proposition of law that special law will override the general law. This position was clarified by the Privy Council in 1941. There was a celebrated case, Maharaja Srish Chandra Nandi versus Rakhal Nanda Thakur. And the Supreme Court, the then Supreme Court, we will say, the Privy Council said it. What matter should be given in evidence as essential for the ascertainment of truth? It is the purpose of the law of evidence, whether at common law or by statute, to define. Once a statute is passed which purports to contain the whole law, it is imperative. It is not open to any judge dispensing power and admit evidence not admissible by the statute because to him it appears that the irregular evidence would throw light upon the issue. The rules of evidence, whether contained in a statute or not, are the result of long experience, choosing, no doubt, to confine evidence to particular forums and therefore eliminating others which it is in arriving at truth, but that which has been eliminated has been considered to be of such doubtful value as, on the whole, to be more likely to disguise truth than discover it. It is therefore discarded for all purposes and in all circumstances. Then this is an principle. This is a principle, and it finds support from the Supreme Court, which I earlier said it, in State of Punjab versus Baldev Singh, AIR 1999, Supreme Court 2378, Constitution Bench. It said it that an illegal search cannot entitle the prosecution to raise a presumption under Section 54 of the Act. It also said that the safeguards provided under the NDPS Act must be complied with. They cannot be compromised. Therefore, the condition precedent prescribed under Section 42 and Section 50, they are to be ritually and mandatorily applied. Otherwise, there may be evidence, but provisions Section 42 and 50 have been violated. That evidence cannot be utilized. No presumption can be raised even on Section 35 and 54 of the NDPS Act.
I think there is again some network issue with our keynote speaker. He'll be back in a moment. Sir, the stream got disconnected. Can you please repeat?
Reverse burden cannot be raised in respect of a person who was found to be on the spot and his mere presence at the scene of crime is not sufficient. This matter was also considered by the Supreme Court in Ismail Khan case, 2000 Supreme Court cases, criminal 1241. They said there is no statutory provision for drawing any presumption that a person who was present at any particular place shall be presumed to be in possession of the narcotic or psychotropic substance. No presumption under law can be drawn, even under Section 114 of the Evidence Act, merely because these persons were present when he was there. Then in section 35, a word knowingly is used. And this knowledge can be attributed only when evidence is there. And section 35 was also section 35 was also subject matter of debate and deliberation before the Honorable Supreme Court. And the case is Bhola Singh versus State of Punjab, 2011 Criminal Law General 2296. Now, special procedure is also there in section 52A of the NDPS Act. You are well aware, though the head note of the section speaks of disposal of seized narcotic drugs and psychotropic substances, but there is a specific provision in this section that the sample of the contraband has to be taken in the presence of the magistrate only. There is no mandate of law that sample can be drawn by the seizing officer on the spot. Though some instructions or rules were there promulgated by the government, which were being complied with by the agencies, but the matter went to the Supreme Court, and the Supreme Court has thoroughly examined the matter and said that any instruction, notification, rule promulgated by the government which come in conflict with the statutory provision cannot be accepted. Section 52A does not authorize the seizing officer for taking sample of the contraband material. The mandate of law is that as soon as seizure is made, material has to be sent to the officer in charge of the police station, who is obligated and mandated under law to produce the material before the magistrate along with an application for making inventory and drawing of samples. One may say that the head note of the section does not speak of procedure for taking sample. It is settled law that head note cannot supersede the express provision made in the section itself. Section is very clear, and it is 52A subsection 2. where any narcotic drugs, substance, psychotropic substance, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances. In any proceedings under this act and make an application to any magistrate for the purpose of A. Certifying the correctness of the inventory, or B. In the presence photographs of such drugs, substances, or conveyances, and certifying such photographs as true, or allowing to draw representative samples of such drugs or substances in the presence of magistrate, and certifying the correctness of any list of samples so drawn. 3. Where an application is made under subsection 2, the magistrate shall, as soon as may be, allow the application. Then subsection 4, notwithstanding anything contained in the Indian Evidence Act or the Code of Criminal Procedure, every court trying an offence under this act shall treat the inventory, the photographs, or narcotic drugs, psychotropic substances, controlled substances, or conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offence. Now, this was clearly explained by the Honorable Supreme Court in (2016) Volume 3, Supreme Court Case 379, and in para 17, it said the question of drawing samples at the time of seizure, which more often than not takes place in the absence of magistrate, does not in the above scheme of the things arise. This is so especially when, according to subsection 2, section 52A, clause 4 of the Act, samples drawn and certified by the magistrate in compliance with subsection 2 and 3 of section 52A above constitutes primary evidence for the purpose of the trial. Suffice it to say that there is no provision in the Act that mandates taking of sample at the time of seizure. Now, if any evidence is obtained violating this provision of law, cannot be accepted. And this provision is mandatory, and perhaps it is not being taken care of. This provision is a special rule of evidence, and it has specifically overridden the provision of the Indian Evidence Act. If primary evidence is not there, maybe illicit article is there, that evidence is not admissible. Admissibility of the evidence is very relevant, and this aspect this is now in Mohanlal case. It is also said actus reus can only be met if the foundational facts are proved beyond reasonable doubt. Now it has a relation. If the evidence is not in tune with the provision of section 42, 50, 52A, then guilty mental state is not available. This presumption cannot be raised. And that's why these are the special provision in the NDPS Act, and this relates to evidence. If evidence inadmissible, that cannot be taken care of, nor recognized, nor utilized at the trial. These were the certain provisions which could be taken care of. And there is another provision that lays down reverse burden in the NDPS. Right. You are well aware, if any property is acquired out of the sale proceeds of the illicit drug, then that property is subject matter of forfeiture. Financial investigation is called for, and it is provided under section 68. 68J says that in proceeding under this chapter, it shall be presumed that property is illegally acquired. But this provision can be utilized only when a notice under section 68H, that is, notice for forfeiture, is issued. Under section 68E, when investigation is carried out, the prosecution is not absolved of showing the real nexus between illicit drug trade and acquisition of the property. What is now going on? The reverse burden is raised immediately, and it is an investigating officer that whatever he says that this property was acquired illegally without there being any nexus between the property and the income, the competent authority accepts that report without carrying into the aspect that there has to be some material, some evidence which could show the connection between the drug trade and the acquisition of illegally acquired property. The legislature has, in its wisdom, made certain safeguards, but how such safeguards are being implemented, it is a large question. Thanks.
Thank you, sir, for such an informative and enlightening lecture. Over to you, Ajay, for the question and answer round.
Namaskar. Uh, with the kind permission of our keynote speaker, I would like to take some questions from the audience. Sir, first question is from Kamal Kishore Thakur. Would be great if little highlight of pre-legislation of NDPS Act or what do NDPS brought into legislation, especially on hemp or cannabis.
Okay. Prior to NDPS Act, the matter was dealt with under Excise Act and Opium Act. The opium material was subject matter of license. And still, opium is used in various drugs. Its production under certain controlled circumstances is still permissible. The possession of church or affine without license was an offense under the Opium Act, 1878. Now you are well aware the substances, such substances, when started affecting the health of the society, at international level, there was demand that we should save our generation and certain legal measures are to be taken, not at municipal level, but even at international level. NDPS Act, as you know, is the result of international covenant and prior to it we had been dealing with such substances under the Opium Act and the Excise Act. International pressure was there, and India, being a signatory to the International Covenant Convention, has to enact this act. The punishment is very harsh, and certain safeguards are to be applied. That's why any enactment must pass the test of constitutionality. The primary legal document, so far India is concerned, it is the Constitution of India 1950. Every rule, notification, order, legislative piece of has to pass this test.
The next question is from Abhishek Khimta. What should be done in order to prevent such acts under NDPS? Should the parents guide their children who are new into such drugs, or let the law be more strong?
Law is just a preventive measure. The real treatment is that the children are to be educated. The ill effects of such drugs and substances. The society has to take a call and educate their children that such drugs are not meant for general consumption. These are only to be utilized, used for use in the medicine. Now, another aspect is when child is forlorn, he is not attended to and given the attention to which he is entitled. He goes astray. Another aspect is easy money. Money is provided to the child at his asking without caring for what purpose he is requiring it. And the society, the company of the children is also to be taken care of. If a child is forlorn and he is surrounded by miscreants, then he is an easy prey. He is then bound to go astray, subject to such substances. Therefore, in my opinion, the lack of communication, supervision on the wards is one of the reason which provide a ground for the child to take to such drugs. Enforcement, as you know, you may pass any law. How it is implemented is the question. It is to be with the aid and assistance of the parents. If parents are vigilant, they provide good care and supervision, it may have a positive effect. Now, on and off, You are aware, chitta, a new drug, new concept, is being supplied even to the school children. Another aspect is, if one is habituated to such drugs, even if money is not provided by the parents, then he is tempted to commit crime. It may start from the home itself, stealing, if not checked, larger scale. Therefore, law is one aspect. Another aspect is the societal control. If law is to be everything, then much would have improved.
The next question is from Abhishek Raj Verma. There are cases when police, in order to evade provision of Section 50 NDPS, shows recovery as contraband thrown from the pocket or seeing police party, but actually it is recovered from personal search.
Yes. Now, as I earlier said it, how law is implemented is a big question. There is a presumption that public servant functions lawfully and he acts in accordance with law. There is a honesty deficiency, I will say. Honesty deficiency, and the public servant does such practice. Not all, maybe some. It is a general tendency seen. But now the search is shown to be from personal. The question would arise whether the compliance of Section 50 was made or not. Now, it is for the accused to bring some evidence to demolish the case only. It is going on, it can't be checked. But at the same time, we cannot paint all with the same brush.
The next question is from Shweta Mohi Sharma. Sir, in your vast experience, how much compliance of strict rules of search and recovery by the police have you seen in cases of NDPS?
One thing I will say, no criminal case is without padding. Padding is done. It is a universal fact. To what extent it is done, that's a different matter. Compliance is shown to be done, but the real test is the evidence. If compliance has not been done strictly, you may find some deficiency. In 40% cases, the compliance is done. And that also depends upon the honesty of the officer concerned.
Sir, there is another connecting question. What is the proper stage for raising objections qua non-compliance of mandatory provisions on behalf of accused?
As we are well aware, investigation is the domain of the investigating agency. there is no role for raising objection. Objections can be raised at the trial only. There is another aspect. If you start raising objection during investigation stage, it will provide an opportunity to the investigating agency to make good the deficiency.
Another question is from Jagan Kumar. NDPS, if any property sees
Seized.
third party, how will get from the court? How we can get it released from the court? I think this is the question.
NDPS is not released. The psychotropic substance, once seized even from third party, it can't be released to anybody.
The next question is from Shweta Mohit Sharma. Sir, what are your views on the status of marijuana being a contraband in India against the self-healing rights of the aboriginals?
Okay. Now, aboriginals used to consume it, no doubt about it. But permissible limit of consumption is still available. If one is addicted to, then he can have it subject to certain limitations as provided in the NDPS Act. Now, NDPS Act is the regulating statute now so far as psychotic substances and drugs are concerned. There is no escape from it now.
The next question is from Himanshu Kondal. What is the key role of primary witness, and what if the adjoining person is not primary witness from whom the contraband was found?
Okay. Now, primary witness, there may be, there may not be. You're well aware the provision of Section 100 CRPC, though requires the presence of the witness at the time of search and seizure. The provision of CRPC are also applicable under the NDPS Act, subject to exception. Even if no independent witness is joined, it is not fatal as per the Supreme Court. What is the philosophy? Philosophy is that if the recovery is witnessed even by the public servants, and if the version is consistent and inspire confidence, it can be accepted. Then this requirement of joining independent witness and non-joining is the fatal is not the rule now. It has to be seen that if the seizure inspire confidence only.
The next question is from Abhinav Mehta.
Okay.
Head notes say all offences under NDPS are bailable, and I think he's referring to Section 37 of NDPS.
As you're well aware, Now calibrated sentences are there. Small quantity, then intermediate quantity, then commercial quantity. He is perhaps referring to Riya Chakravarti case. As I earlier said it, head note of a section cannot control the express provision of law made in this section itself. Head note says all offences are non-available. But the section does not speak of small quantity. Small quantity is something else which is not controlled. The punishment is less than 1 year. Any offense punishable with less than 3 years is to be regulated for the purpose of the bail under the CRPC, Schedule 3. And this matter was subject to matter of judicial interpretation, and the Honorable Delhi High Court Divisional Bench has said it, that small quantity offences are bailable one. According to me, the Bombay High Court decision overlooks this aspect, that the punishment is calibrated one, so all offences of small quantity are bailable.
Sir, next question is from Bhavnish. I think there's some technical problem.
Okay.
I think all the questions are over.
I think now, yes.
I'll call upon my fellow friend Shri Ajay Singh ji for the vote of thanks.
Sir, I'm really feeling honored and privileged that Shri B.L. Soni ji shared with us his valuable knowledge and experience and enlightened us on the topic of reverse burden of proof in NDPS and special rules of evidence. This lecture was really helpful to all of us in understanding the tenets of NDPS Act as well as special rules of evidence. He has always played a pivotal role in guidance to the young advocates, and I, on behalf of Himachal Pradesh Adhivakta Parishad, is really indebted to him. And once again, thank him for giving us his valuable time. And we are really indebted to you, sir. Thank you, sir.
Thanks. Welcome.